Thank you, Miriam. So this evening's lecture will address several topics. The cute name is Where There's a Will, There's a Way. Okay, does this make it even sound more baritone? As I do with all lectures of mine, I'm giving you general information at this stage. This is not intended as a legal opinion. Issues that are raised here, first of all, should be kept hopefully to the end unless I make some glaring error or you have some major question. But you should all consult with your own personal lawyers regarding any questions that you may have regarding the contents of this lecture. So basically, over the years, I've given several lectures, Nefesh B'Nefesh, other organizations, regarding the documents which are suggested in different stages of one's life. I realize I actually probably should try switching this to the other side. Is that better? Okay. Now you can see it better. Okay. So the general documents which I suggest people consider having is a power of attorney, and I will discuss all of these documents separately. An ongoing power of attorney, which is something brand new, only came effective in the law in May. Not that many lawyers are able to do it yet. A healthcare proxy, which I've always been a big fan of having people sign regardless of your physical condition, mental condition, etc. It's appropriate at any stage of one's life. There have been new changes in the law, which I guess is redundant. There have been changes in the law which change both the format of the document and what needs to be done to the document once it's been signed. A living will, that's the term that's used in other countries in the States, basically talks about end-of-life decisions. Once a person is considered to be what we in the old country called hospice care, you have the opportunity up front to make choices as to what type of treatments you want, what treatments you do not want, and a testamentary will, ironically the subject of the lecture, is the last one that I will be addressing, but it is the document which addresses disposition of one's assets at the end of life, after a person passes away. So as I said, the first document that I'm going to discuss is a power of attorney. A power of attorney can have two different flavors. One is a limited power of attorney, and the other is a general power of attorney. A general power of attorney gives authority to the person who you are empowering to do anything that you yourself could do. Therefore, as I'll mention in a few seconds, you should only give that authority to somebody that you trust intimately. If there's somebody that you are hesitant about and that you feel you don't have complete confidence in, that's probably not the person you should give a general power of attorney to. A limited power of attorney, by its nature, means that the authority is limited. It can be limited either for a period of time, it can be limited to a subject, it can be limited, for instance, if you're sending somebody to go to the post office for you, the document that the post office requires to demonstrate that you have the authority is a limited power of attorney. If you're having your car inspected, you'll generally have to give a limited power of attorney to somebody else to go to the inspection station on your behalf. But throughout one's life, there may be many reasons why you would consider giving either a general power of attorney or a limited power of attorney. So for instance, if you're about to travel abroad and you want to make sure that somebody has the authority to act on your behalf in Israel, generally, or to a limited extent, so you would give one of these documents. A general power of attorney, generally, must be signed in the presence of an Israeli notary. For those of you who have not yet had the pleasure, either in buying a home, selling a home, or taking out a mortgage, where you generally require to provide a general power of attorney, the notary public is something different than it is in the old country, in the States. When I say old country, I mean the States. A notary there is basically anybody that passes a civil service exam. In some states, for instance in New Jersey, a lawyer is automatically in place of a notary. In New York State, at least when I was last there 20 some odd years ago, a lawyer could automatically become a notary. In Israel, a notary is a big deal. You have to have either 15 years of experience, some combination of being a practicing lawyer. You have to submit an application. You have to be approved by Misrad Mishpatim. These days, you have to go for training in order to become officially a notary. That wasn't always the case, so that is the case now. But the fact of the matter is that a power of attorney, whether it's general or limited, expires and has historically expired, generally speaking, once a person is no longer mentally capable. So you may ask, well, what is it that you'd want to have a power of attorney for? So first of all, again, when you're doing virtually any transaction in Israel which requires somebody to act on your behalf, you have to give them a power of attorney. If you're doing a transaction, for instance, the purchase or sale of a house, normally the seller would give the lawyer for the purchaser a power of attorney to enable the other side to complete the transaction if they, for whatever reason, are not available. That kind of power of attorney generally continues to act even if a person is not mentally capable. But for the most part, a limited power of attorney and a general power of attorney in Israel are used when a person is not physically able to do something, either as the example I gave a moment ago, because they're traveling abroad and they need somebody to be present in Israel to do something on their behalf, or if, God forbid, somebody is injured and they're infirm, they can't leave their house, they can't go out and do things, somebody becomes elderly and it becomes more difficult for them to get around, you can give a power of attorney to somebody to act on your behalf, again, either generally or in a limited capacity. So what happens in Israel once a person is no longer mentally capable? Well, again, in New York and many other states in the United States, you had what's called a durable power of attorney. A durable power of attorney continued to be effective in New York State and many other states, even though a person is no longer mentally competent to act on their behalf, and therefore the authority would continue there notwithstanding the mental incapacity. However, in Israel, again, until May, that option didn't exist. When a person became mentally incompetent, the power of attorney lapsed, no longer had the authority, and the only option available to people until May of 2017 was to have a family member or somebody else appointed as an apotropos, a guardian. So again, the options at the time were person themselves being able to act, limited or general power of attorney for as long as the individual who is giving the authority is mentally competent. And once the person started to be of diminished capacity, the only option until now was to appoint a guardian. For those of you who have not yet had the experience either with friends or relatives, the guardianship procedure in Israel basically removes from the individual the authority to act on their own behalf. In fact, part of the process to apply for a guardianship, apotropos in Israel, requires the submission of a psychiatric report in a specific form, together with a court application, in which the psychiatrist will attest in the document that John Smith is no longer mentally capable. And then the petition is filed with the court, together with the substantiating approval of the psychiatrist, and the guardian is approved. Also, until now, until May of 2017, an individual did not have the opportunity to select who would be their own guardian. What usually was left to happen was that once a person became mentally incompetent, usually a family member would start the administrative proceedings, contact the psychiatrist, get a psychiatric opinion, file a petition, usually hiring a lawyer to do that on their behalf, and once that became effective, the individual no longer was able to act on their own behalf, and the apotropos was appointed. Israel came into the mainstream in many European countries, not yet so much in the United States, notwithstanding, as I mentioned, in the United States you have the durable power of attorney, but the purpose of a durable power of attorney is a little bit different. The ongoing power of attorney, or some people call it the enduring power of attorney, Yipui Koach Mitmashech, has two initial functions. One is to bridge the gap between the time when a person is no longer mentally competent and the power of attorney that has been given up till now stops working, and the time when an apotropos needs to be appointed in order to take away from the individual and to appoint somebody to act on their behalf. The new enduring power of attorney, ongoing power of attorney, fits in between. It allows a person, once they're in anticipation of when their mental capacity may start to slip, to have somebody appointed to assist them and to work in parallel with them in functioning, in making decisions, in implementing decisions, something that didn't exist until 2017 in May. The enduring or ongoing power of attorney has a broad range of options. It's a lengthy document. It has to be certified together with a lawyer who has gone through training, which ironically the Israeli way, the law didn't come into effect until May 2017. The training for lawyers who were willing to do that didn't start until the end of May 2017. And the first group that was trained in Tel Aviv only got their certification the beginning of June 2017, even though this law is already in effect. And in Jerusalem, the first group of lawyers in which I was a member only got their certification in the middle of June. They're now going in Beersheba, I think in Haifa. So gradually throughout the country, there'll be a limited number of lawyers who will be authorized and respected by the Apotropos HaKlali, which is the Guardian General, in order to enable people to sign this authority, giving an interim option to people before they're no longer completely incompetent. The document is not a halachic document. I'm actually not going to speak much about halacha. I have enough issues dealing with civil law. I'll touch upon halacha in the end. But the ongoing power of attorney is not a halachic document. However, it, and I'll speak in a second about the healthcare proxy, allows you to cater the document to include within it provisions which are consistent with your halachic perspective, your civil, your emotional needs. You can designate in it, for instance, that you want John Smith to be able to assist you in making decisions, but not decisions that would require you to leave your home. You can authorize the person to give authority to submit the individual to competency exams, to hospitalize them in a psychiatric ward or in a psychiatric hospital, or you can eliminate that option. There are many choices that you have in this new concept, the ongoing power of attorney, which was not available previously. Again, it does not mention halacha specifically, but within the optional paragraphs, you have the opportunity, for instance, to say that this document will only come into effect when Rav X determines or certifies or approves whatever action needs to be done, or that a particular action can only be done with the approval of a specific Rav or a specific group or a specific halachic perspective. But there are many choices that you have in the document that you did not have available to you previously. There's another concept which is not yet effective, which is somewhat lower than the authority that's given in the ongoing power of attorney, and that is a supporter. For whatever reason, the legislation has not yet sufficiently clarified the role of the supporter, the documents that need to be signed to authorize the supporter. So the supporter is a bit of a lower level. I guess if I were to establish a range, you would have the general power of attorney or the authority that somebody can make on their own decisions. You would have the supporter, which isn't available and likely won't be available for another year. You have the authority that's granted by the ongoing power of attorney. And then ultimately you have the authority that would be given to a guardian to replace and cancel your own volition and ability to make decisions and to substitute it with the guardian. The next document, which I have always been a big fan of, has been the Healthcare Proxy, and I recommend people of all ages, health condition, mental condition, everyone should have that. I will be honest that the recommendation that I gave historically until May of 2017 was much more general and free than I would today, and free is actually an operative word because the process now is much more complex than it was previously, and I frankly did not charge people. If they came and did a will by me, I usually did not charge them to do a healthcare proxy. It's something that I consider to be important. It's a service that I provided. I didn't charge people for it. Today, this and the process of appointing an enduring or ongoing power of attorney requires a substantial investment of time explaining the options, preparing the document, meeting with the people, the computerization of the process, which is supposed to make it easier, probably makes it easier for the regulators, but not for the lawyers and the people that do it. You have to go through the document, explain both in the ongoing power of attorney and the new healthcare proxy. You have to explain all the options. They go through them, they check them off. Usually I prepare them in advance before the people who will come in and then discuss the issues. You have to then print it out, have it signed by the individual, both the ongoing power of attorney and the healthcare proxy. You then, after it's printed out and signed and certified by the lawyer, have to scan it back into the computer system. Then you have to count to 10, hope that the computer system works, which sometimes it does, sometimes it doesn't, in order to file it with the Apotropos Haklali, the Guardian General. Then only once that computerized process is approved for the ongoing power of attorney, then do you have to file it physically, the document that's already originally been signed, with the Apotropos Haklali, the Guardian General. You have two options with that, and then I'll get back to the healthcare proxy, but I got off on a tangent. The ongoing power of attorney, one of the requirements that the legislature has established is that it needs to either be filed with the Apotropos Haklali by this lawyer who has received the training and has prepared and certified the document, or by the individual themselves, who needs to go physically to the Apotropos Haklali, say, here I am, here's the document that my lawyer who is certified has prepared for me and witnessed, and submits it themselves. Hasn't happened, as far as I know, that hasn't happened yet. My suspicion is that most people suspect, as I do, that the reason the legislature makes this requirement is that when the individual shows up at the door of the Apotropos Haklali, they're going to ask them questions to see if they're really of mental capacity, if they really understood all of the documents that they signed in these capacities. They are complex. It takes time to explain them. They're all so far in Hebrew, although in our firm, regarding the ongoing power of attorney, we prepared an English language questionnaire which addresses many of the choices that a person has to make in the ongoing power of attorney. The healthcare proxy, which until May of 2017, was available in English, Hebrew, and Russian, perhaps other languages, but I know of those three. And our firm many years ago had prepared a side-by-side translation of the Hebrew text with the English text. And the reason we did that is our feeling is the healthcare proxy, which I haven't even described what it does, but the healthcare proxy needs to be reviewed by a doctor. Usually a doctor who's under time constraints and pressure because the individual who signed the document requires some kind of medical care. At the time when your doctor, who is probably not or may not be a native English speaker, some of you may be lucky enough to have regular GPs that are, but when you go to the hospital, you never know who's going to be treating you. My feeling has always been it's better to have it in a language that the doctor is likely to be more comfortable with. And since all doctors in Israel need to be certified in Hebrew, so I always had the dual language form. The new form, however, of the healthcare proxy is only available in Hebrew. We have an unofficial translation into English, but in contrast to the old-time healthcare proxy, which still is only usable until if you signed it up till April of 2017, basically was kept by the person who was authorized in their drawer or given to the friend, put in a file cabinet. If or when it became necessary to be used, the person who was authorized took it out and said, John Smith gave me authority to make healthcare decisions for them. Again, the healthcare decisions are made pursuant to this document only at a time when an individual is not his or herself able to make healthcare decisions. We're not talking now about incompetence. It could be somebody who was in a car accident, somebody who fell on the street and is unconscious, somebody who's going to surgery and is only likely to be unconscious for 2 hours, 3 hours, an hour, half an hour. Somebody needs to be authorized to make healthcare decisions for that individual at the time when they can't make the healthcare decision on their own. So the Healthcare Proxy gave that authority to somebody else. Up till now, nothing had to be done with it. Under the new law effective in May 2017, anybody that did not sign a Healthcare Proxy by April of 2017 now has to have that Healthcare Proxy also filed with the Apotropos HaKlali within 1 year from its being signed. If you sign the Healthcare Proxy in the presence of the lawyer and certifications and whatever, and for whatever reason it was not filed at the Guardian General's office within 1 year, it's as if you didn't do it in the first place. So you may say to yourselves, as I did when I was first told about that, what's the point of either giving the initial authority temporarily, or why limit it to 1 year? And the answer is a practical one. Ideally, they would want the Healthcare Proxy to be signed and immediately filed with the authorities. That way, if it's ever searched for, it's there, it's done properly, it's already approved, and nobody has to worry about it. You know that if John Smith comes into the hospital, the first thing they will do is they'll put in his ID number, whether it's a Teudat Zehut number or a passport number, and they'll see John Smith gave a Healthcare Proxy. Who did they authorize? Chaim Yankel. So then what's this 1 year? So my guess is, or my interpretation of what we were told in the class, is, for instance, in the States, not as common in Israel. As soon as you go into the hospital, one of the first things the doctors do is they require the individual to sign a Healthcare Proxy. That way they make sure right away that an individual has the authority to act on behalf of the individual who's no longer temporarily able to care for themselves. If you didn't do it, and you're now in Israel walking into Shaarei Tzedek, you're about to have an operation, you're standing there at the reception area, and they may or may not encourage you at the time to make the difficult decision, okay, who do I trust? Who has the hashkafa that I have that will make decisions? Do I want to, if the need arises, get a transfusion? Do I want to donate organs, which is more relevant for another document I'll speak about in a second also. But even if under those time constraints you make a smart decision, the authorities still want to make sure that it's recorded somewhere. So they basically give you a 1 year grace period in order to register the document that you may be doing under, I don't want to use the word duress because we'll see that has other meanings as well, but at a time when you're under stress, and you may, if you hadn't planned previously to give authority to somebody, so you'll give it to them, so you can throw it out afterwards. If you don't have it filed within a year, it lapses. But if you want to make sure it's done correctly, even if you do it under stress in the hospital shortly before you go into a procedure, so you'll have this document working temporarily, and hopefully within the year, either you will have it redone, or if you still find the document itself to be acceptable, you will take that document and have it duly filed. Let me go back one more second to the ongoing power of attorney, because it's something that I touched upon, I mentioned, but I didn't really address. I said previously that until now, you only had the option, if you were giving somebody else authority, to give the power of attorney, which lapses once they're no longer mentally capable, and then the next step would be to have the appointment of a guardian. The ongoing power of attorney addresses this interim period, this supporter provision, which doesn't exist yet, a little bit beyond that. But what about when the time comes to appoint a guardian? A person is no longer, psychiatrists, doctors have determined, no, sorry, even with help, this person is no longer able to make their own decisions regarding their own well-being, whether it's for their personal assets or their care. Until now, you had no opportunity to choose who that person will be if or when the time comes when you're no longer mentally capable. One of the separate documents that is an addendum, I would call it, to the ongoing power of attorney allows an individual today to choose who they want to be appointed guardian in the future at the time when they're no longer able to make their own decisions about their care. In my opinion, probably not as necessary for young people in their 20s or 30s, but certainly I think when people get into their 40s and 50s and maybe a little bit later, better health, perhaps not as good health, having these documents, these tools available which weren't available previously, I think is an important thing for everyone, virtually everyone, to consider. Again, whether you want to also include the appointment of a guardian is a different story. So now in the healthcare proxy, as I said, you're designating somebody to make healthcare decisions regarding regular life procedures, ongoing. A person is not gravely ill at this point. They just need somebody to make healthcare decisions because they're unconscious, they're going into a procedure. So you appoint John Smith to take over and to make the healthcare decision when you yourself cannot do so. And what happens if the doctors disagree? John Smith, who's been authorized by the healthcare proxy, says, I don't want procedure X. I don't think that John Smith is going to recover. I don't want to put them through this procedure, whatever the procedure is. So the doctors can convene a committee of 3 doctors. It's called the Ethics Committee in the hospital. And the committee of 3 doctors have the authority to overrule the decision of the person who's been granted the authority under the healthcare proxy. Well, then you may say to yourselves, well, what's the point of then having the healthcare proxy in the first place if the doctors can overrule? Well, from my experience, that doesn't often happen. It does sometimes happen. John Smith, who has the authority, says, I don't want this procedure. Doctors are more optimistic. They think that there's a good chance of recovery. They do think it's appropriate to have the procedure. They'll have a discussion. The doctors will discuss it with the individual. Part of the process of the healthcare proxy is to give authority, if you want. Most people, actually, everyone that I've ever done it with, either on the old format or the new format, gives authority at the same time the individual to appear before the committee of doctors, and they'll discuss it. The person will say no, the doctors will say yes, and the person says, I'm not convinced. That's when the lawyers come in. That's where you go to court, and you'll have the committee of 3 doctors from the hospital which will take position X on behalf of the hospital, and you'll have the individual with the healthcare proxy that will be arguing pursuant to the authority granted to them in the healthcare proxy. Not an ideal situation. It does happen, but usually the healthcare proxy authority is respected only if it's a radical decision. Usually do the doctors convene a committee to attempt to overrule it, and frankly, I've been doing this for lots of years. I don't know a case where there's been that dispute that has gone to court, with one exception, and I'll get to that in the next document that we'll speak about, where there has been a radical event that I've been familiar with in the past. As I said, the new format, the old one that many of you may have received from your hospitals no longer works. If you got it in your hospital and you signed it by April, that's great. If you didn't sign it by April, it's no longer valid. You can't use that form. You need to use the new format that's been approved by the Apotropos HaKlali, still so far only available in Hebrew, needs to be certified, and again needs to be filed within 1 year. So if you've already done it, so kol hakavod, if you've done it by April, you can rest assured that it should be recognized. If you've not yet done it by April, you should use the new format, and I feel strongly that virtually everybody should do that. The next generic document before we get to the testamentary will is a living will. It's basically Hanchayot Rufuyot Maktimot L'Choleh Hanoten Lamut, which is a Hebrew not as nice way of saying that end-of-life decisions. A person who is what doctors would determine to be in the last stages, hospice care, usually 6 months, as determined by a doctor. You have the opportunity in this document to make decisions as to what specific treatments you want what specific treatments you do not want. Usually, this document, the living will, is drafted and signed in conjunction with the healthcare proxy. Because if you only have the healthcare proxy, you don't have the opportunity to designate which treatments you want, which treatments you don't want. Conversely, if you only have the living will and you've expressed what your own opinions are and preferences, you haven't given anybody the authority to advocate on your behalf. So if you're going to do a living will, you should also do a healthcare proxy. If you do a healthcare proxy, you do not necessarily have to do a living will. This is one of those documents that I do not personally advocate people sign. Many of them do. I've had many clients who felt strongly that they wanted to make the choices as to what treatments they want at the end of life and which ones they don't want. The document is extremely detailed. Anything you can imagine in a healthcare decision for end of life, you'll find in this document. One of the reasons that I find from a practical point of view that people generally do not do this document, aside, I think, from the psychological barrier, everyone knows they're going to die at some point. So you do a will because you want to address how your property is going to be disposed of, and God willing, it won't happen till 120. Okay, I like that. You want to be there when it happens. A healthcare proxy, thank you. I may use that in my next lecture. A healthcare proxy, anybody of any age and health can fall and get hurt and need somebody to care for them. When it comes to end-of-life decisions, you really have to think about what you want, what you're asking for, and realize that under many circumstances it may be an irrevocable decision, because you may and hopefully would only be able to sign the document today when you have the mental capacity to make a decision and you say you don't want treatment X, or even if you do want treatment X, and who knows how somebody would otherwise feel at the end of time when it needs to be decided. You'll have made that decision. It's a difficult decision to make. One of the you probably can't read this. This is just the first page of what we use as the living will. The living will, by the way, is also a statutory format. Officially is only available in Hebrew. For those of you who have good eyesight, we did a side-by-side translation again so that people can see what they are choosing on the Hebrew side by reading what it says on the English side. But this must be used in the format and the choices set forth in the law by the regulators. The document must be completed together with the involvement of your personal physician. And your personal physician must certify on the document what your current physical condition is. I suspect, again, that aside from the psychological difficulty of people making these decisions in the first place, if or when you see what this document is, it's 6 pages long with many numerous choices on it, and to expect most doctors who are usually rather busy to sit there and explain the ramifications as they're supposed to of each choice that a person makes. If they don't get nutrition, if they don't have hachaya, CPR, if they don't have a feeding tube and they can't eat, obviously at some point we all know intellectually what the result is going to be. But the doctors have to sit there and explain the various choices to the individual, and my guess is most doctors don't have the patience or time to do that. Again, that may be one of the reasons I find people have a difficult time making these choices, although over the years I have had a handful of clients who have done the living will. That's an individual decision. I personally wouldn't do it, and I don't recommend to anybody something that I wouldn't consider doing myself, but many people feel very strongly about it. Those people that feel strongly about it, they should know that this tool is available to them. So now we get to the colorful name of the lecture, where there's a will, there's a way, and of course it was to some extent tongue-in-cheek referring to a living will as well. But my guess is, other than for those of you who knew about the existence of the new ongoing ongoing power of attorney or the new form of healthcare proxy, my guess is most of you are here to hear about what happens with wills. So the question is, why do a will? Obviously, you're not going to be around once despite Woody Allen, but you're not going to be around to deal with whatever after you're no longer there. And that's exactly, in my opinion, why it's important for everybody to have a will. I've had people in their mid-20s do wills, and 20 years later, still clients of mine, they're still doing fine, but they wanted to arrange their affairs so that at that time, in the case that I have in mind, a person wasn't even married yet and wanted to ensure with an E what happens to her belongings after she passes away. There are default provisions in the law which I'll speak about as well, but when you're alive and you have the opportunity to express your testamentary preferences in a will, the way to do it is in the document. If you don't have the document, or the document was not done correctly and properly, it won't be effective and you won't be able to express or have honored your desires as to what happens to your things after you pass away. Similarly, you have the option of designating somebody to manage your property once you pass away. That's called either an executor, in the male form, executrix, administrator, if there is no will, or administratrix. Minaheli Zavon in Hebrew is the complementary term for an executor. That is the person who technically would be authorized to manage the estate, the property that a person had when they pass away after they're no longer around. In the States, for instance, in New York, where I'm licensed as well, I used to be licensed in New Jersey, but it's been years since I've dealt with New Jersey law, other than, ironically, when it comes to wills, I let that license go. But in New York, when a person passes away with a will, the executor who is approved by the court gets what's called letters testamentary, and those letters are basically a certificate or certification to the executor to go to all the various authorities and say, the court has approved that I will be acting on behalf of the estate. I will be acting according to the instructions of the will. But in New York, for instance, the person only needs to see that document in order to respect the instructions of the executor. In Israel, it's a little bit different. Actually, it's quite a bit different. In Israel, I would say 95% of the time, you do not have the official appointment by the court of an executor. The process in Israel is, if there is a will, or even if there isn't a will, the court will approve either the will itself or the default provisions of the law as to how the property should be managed. And only if there are extenuating, unusual circumstances will an Israeli court consider, even allow you to submit the application, which is a separate legal process, to appoint a Minaheli Zavon. And they will only do it under extreme circumstances. So then you'd say, I like to ask myself questions in anticipation of these lectures. Well, why appoint an executor in the first place? Two reasons. First of all, regarding property outside the country. Many of my clients have property both in Israel and in other countries, in particular New York State or other states, and when it comes to administering the property in those other locations, so then the court will look to the will to see who was designated to be the executor to manage the property in the estate, and will generally tend to approve and authorize that individual. In Israel, in the event that there is no official appointment of an executor, which generally happens, there is no appointment of an executor, the heirs of the estate will submit to the court the will. The court will approve the will, hopefully, if it's done properly, which will designate what is to happen with the assets in the estate. And then the heirs will take the approved document by the court and take it to the bank to change the title in the bank account, take it to the land authority to change title in the apartment or whatever, which actually brings to mind an important thing that not necessarily that I wanted to mention, although I think I touch upon it a little bit later. Those of us who came from the States, many other countries are familiar with joint ownership of bank accounts, of apartments, whatever. In the States, many other countries as well, New York in particular, of the United States, there's an immediate automatic right of survivorship. So if you have husband and wife, for instance, who jointly own a bank account, or husband and wife, or brother and sister, or whatever the relationship, have title in an apartment, or in a boat, or in stock certificates, when the first person passes away, it automatically is owned by the survivor. Usually all that's required is to present a death certificate, depending which country, whether it needs to have a certified translation or not, putting aside for a second tax ramifications, which might also be relevant. But outside of Israel, jointly owned property, when the first person passes away, the survivor automatically owns 100%. In Israel, that's not the case. It's not the case with bank accounts, it's not the case with apartments, it's not the case with anything. When you have jointly owned property, usually, there are some exceptions, but when you have jointly owned property and the first person passes away, the survivor does not automatically own 100%. The half that is owned by the person who passed away becomes part of the estate of that person and would be distributed if there is a will according to the instructions of the will. If there is no will, according to testamentary, to intestate succession, which is basically the default provisions of the law. So if you have jointly owned property and you're concerned, as you should be, because I've had many cases with many different amounts of money, usually it often comes to a head regarding bank accounts. You have the surviving spouse that needs access to the bank account, and as soon as the bank finds out that the first person passed away, and they usually find out rather quickly, the old way, they would automatically freeze the account. Then approximately 20 years or so, the banks came up with a document called Arichut Yamim. What the Arichut Yamim does, which is not what many people think that it does, when many people think that it does, they think that it makes it work like in New York or other countries, that it creates a right of survivorship, which it does not. The Arichut Yamim document, which was created about 20 years ago, allows the survivor to use a limited amount of the balance in the bank account for a limited period of time in order to allow that person to file the probate proceedings in court in order to have the court determine who gets to own that bank account. But it is for a limited amount. They're not usually very generous. About 15 years or so ago, it became standard procedure for all banks, almost all banks, usually when they open up new joint bank accounts, to suggest and encourage people to sign this Arichut Yamim form. So the first homework that I give to all of you, whether or not you do a will or didn't do a will, if you know for sure that you did the Arichut Yamim document at your bank, great. If you're not sure, contact your bank. Certainly if you did it more than 15 years ago, you should certainly do it. Check with your bank. I would be on the safe side even if you did less than 15 years ago. Contact your bank, say, I want to make sure, did I and the other person sign the Arichut Yamim? Fine, great. You know that you'll have a limited period of time after the first person passes away to deal with the money in the account, but it makes it much easier than if the account would be automatically frozen. Getting back to the reasons why you would want to consider doing a will, you want to, if you have minor children, you have the opportunity to recommend to, again, this apotropos haklali, the guardian general, who you would prefer take care of your minor children until they become of age. If you don't have that expressed in your will, the court will have no way of knowing what your preferences would have been. They're not bound by your recommendation, but if you don't make your recommendation in the will or somewhere else, the court will have no way of knowing what your preferences would be. to avoid arguments among heirs. That usually doesn't happen as much regarding money. In a small case, it happens a lot regarding money in big cases, but usually the arguments among heirs is regarding things, items. If you want to avoid, to the extent that you can, disagreements between your children, grandchildren, relatives, friends, neighbors. I've had elderly clients who were widows or widowers and didn't have anybody other than distant relatives to leave things to or stuccoed, which many people do. But if you don't have a will, you don't have the ability to say, okay, I want this relative who came to visit me frequently, I want to give them something that meant something to me, the Kiddush cup that I inherited from my grandfather. If you don't have a will designating the specific items, you are hoping that your relatives are not going to fight over particular items. Unfortunately, I've handled many cases where that's not been the case. I may give an example in a little while, but if you want to avoid or minimize the chance of arguing among your heirs, the will is the place to do it. Minimizing taxes, I'll also talk about that in a second. Israel, it's not so relevant. Israel does not currently have an inheritance tax, or the less nice way of calling it is a death tax. The United States does. They have a federal estate tax. They have a state estate tax. They have different thresholds and exemptions, which I will talk about. So if, for instance, you live in Israel, but you are a U.S. citizen, if you have more than approximately $5.5 million on worldwide assets, that means assets in the States, assets in Israel, assets in Switzerland, which haven't been found yet. Maybe they will, maybe they won't. But the federal examiners in the States will look at the value, and you can somewhat easily reach that amount. It would surprise you. You own an apartment, you may have insurance, you may have all kinds of things that without that much difficulty you can reach the $5 million level. And I don't want to wish anybody whatever, but hopefully it would be an issue for most of us. But if so, from my experience, at least people from the United States, if you live in Israel and you're not subject to a state estate tax, usually taxes is not the reason why you would be doing a will these days. When the exemption was much lower in the United States, the federal estate tax exemption, that's a different story. And then lawyers did fancy trust agreements, and you had 30, 40-page wills with all this trust and that trust, spendthrift trusts, all kinds of fancy names of trusts, mostly done, in my opinion, in the old days and probably to some extent today, because lawyers make a lot of money doing trust. It sounds fancy. People don't usually understand it. These days, it's very rare, unless you approach the $5 million range. If you're talking about a U.S. citizen, you're not really going to have these long, fancy wills with trust that you used to have. One of the reasons why you don't want to have it from the old country is that if you have a will that was done outside of Israel in English, usually when the person passes away, it will then have to be translated into Hebrew, and oftentimes with a notarial certification of that translation. And I can tell you that costs a fortune. The old-fashioned wills that were 30 or 40 pages long can easily cost 10,000 shekel to translate and certify. And I've had cases where they've hit 15,000 shekel. Even if you had, God willing, you have more than $5 million, $5.5 million of assets, and you have tax considerations, I would still say to you, you need tax plating for the United States, have your nice long will for the United States, and have a separate will which will address only your property in Israel. And then when the time comes, you have property in Israel, the much shorter will, and in fact, if it's done in Israel, even if it's in English, you usually don't have to translate it anyway. You only have to, usually these days, because there was a court decision a couple of years ago saying it was prejudiced against English speakers, English language wills that are done in Israel usually do not have to be translated at all. If they were done outside the country, they usually will have to be at least translated, if not notarially certified. And if it's a long one, it's going to cost your heirs a lot of money. and you would probably prefer to have that money go to your heirs rather than go to the notary or whoever else. I'm a notary, but I try to have my client's interest in mind. I believe you should save money. This is not a way of saving money. Providing gifts to charities. I'll talk in a second about intestate succession. If you don't have a will, the courts will apply the local law to how your property should be distributed. One of those choices is not to give to a charity. You don't have any ability to designate a charity as an heir to your property after you pass away. I would say, if I had to be honest, that not that many of my clients who have immediate relatives do have provisions going to charities. However, some people, and I won't again get into the halakhic aspects, I'll touch upon halakhic aspects at the end, but some people feel they have to give maser of their belongings at the time of death. Whether you halakhically do or you halakhically don't, if you have a will, you can say, I want 10% of my net assets to go to Yad Sarah. Nefesh B'Nefesh is a great institution to support. I don't get paid for that. It just I don't get paid. But anyway, you don't have the ability to designate any charities that would receive upon your demise if you don't have a will. So the state oftentimes has automatic provisions if you don't have a will. If you die without a will, and for instance you have a spouse and no children, usually the spouse will inherit 100%. If, however, you have a spouse and children and you don't have a will, usually the spouse will get half of your share and the other half will go to your children. Most people, that's not the way. I've been doing this for 30 some odd years, 26 in Israel, I guess another 10 in the States. From my experience, very few, although there have been some, don't prefer that their spouses receive 100%, perhaps with some exceptions that they want particular items to go to somebody, or maybe to tzedakah, to some charity, or particular items to go to particular children. Everything else goes to the spouse. After the second person passes away, then everything would go to the children, to neighbors, friends, tzedakah, to whatever. But you don't have that choice. If you don't have a will, the law of the jurisdiction will determine how your property is distributed, and sometimes those rules are quite complex. If you have somebody that passed away that lived in the States and left property in Israel, it depends on what the property is. In some cases, the rules of Israeli law will apply to the distribution of assets, and sometimes the law of the country where the person lived will control the assets. Usually comes up regarding bank accounts or stock that happens to be in Israel, and the Israeli law for intestate succession says X, and the law of Florida or New York says Y, and then the courts will see, well, do I apply this law, do I apply that law? And by the way, one of the things that the courts usually require when a will is done outside the country, was done outside the country, is to have a legal opinion from a lawyer in Israel, usually who is licensed in that other country. So that, for instance, if you have a will that was done in the United States, in New York, and the person left assets, property in Israel, and you want to probate that will in Israel, so a New York State lawyer who is also a lawyer in Israel needs to give a legal opinion, and that legal opinion is in the form of an affidavit. It's a fancy document, talks about the background of the individual, their experience, how they think that they know what's going on in New York. Usually it's because they're licensed and practiced law there for many years. And they submit that to the court, and the Apotropos HaKlali, again, they're the name that comes up a lot. They will evaluate the legal opinion, decide whether they agree with it, see whether it's deficient or sufficient, and will make the recommendations to the court, and the court will then rule usually in conjunction with the recommendation of the Apotropos HaKlali. I won't go into the various examples here of what happens with various assets. Bottom line is, my recommendation, you should have a will. One of the other complications of intestate succession is, who are the heirs? Even if you say that I didn't have a spouse when I passed away, God forbid, but I did have children. Who are the children? Well, if you made Aliyah and your children were younger, your children are likely listed on your Tudat Zehut, on your Sefach, on the white page that comes with your Tudat Zehut. If you had children that were born outside the country, or you made Aliyah at a later age and they don't appear on your Sefach, then you have to prove who your children are, or the heirs. You won't be around anymore. Your heirs, God bless you. Your heirs will have to prove, sometimes with a birth certificate, sometimes by affidavits. They will all be complex, require apostille certification, which I won't talk about now, but you would be making your heirs' lives much more difficult by having to prove that they are your heirs in the event that you don't have a will than in the event that you do have a properly done will. I mentioned previously about managing the estate, the executor. One of the important reasons that in Israel the courts refrain from officially appointing the executor is because executors earn fees. They take a percentage of the estate. Usually in the states, in New York, for instance, it's a sliding scale which goes up to 3 or 4%. In Israel, under some circumstances, that can happen as well. But if you have family members, usually family members, certainly if they're close family members, will not charge the estate for the services that they render to manage the property. And Israeli courts generally prefer to preserve the estate for the heirs rather than paying an executor to provide that service. I personally have accepted appointment as an executor in a few rare occasions where somebody did not have any immediate relatives. They didn't know who else would take care of their belongings afterwards. It's a lot of work. If you're not related, even the money that you get will never amount, generally, unless you have a tremendously large estate, will not cover the tircha and the work that the individual as an executor needs to do. It's much preferable to have the family members do it. The other reason the courts don't like appointing an executor is an executor has what's called fiduciary obligations. They have a duty to act properly towards the estate. They are monitored by the Apotropos HaKlali. There goes that name again. You have to have motions and reports periodically submitted to the Apotropos HaKlali and to the court. The Apotropos HaKlali makes all kinds of quite helpful comments and suggestions as to what should be done, what should have been done, what shouldn't have been done. If you have family members who are able to manage your property after you pass away, I still recommend that you designate an executor in case there is a complexity, there's litigation going on, there's some problem regarding property that it will require an investment of time that the individual heirs are not going to be willing to invest. The most recent case where I was an executor, this again one of the elderly ladies, passed away and left I think 25 heirs. And none of the 25 heirs were willing to step up to manage the estate. And I had accepted the kavod in the original will when I was perhaps a little bit more innocent than I am now. But it is an important function. If you don't have a family member that would do it without charge, then you should probably consider giving it to a family member that will charge. And if you don't have a family member that will do it for free or for pay, then you should recommend some professional, whether it's a stockbroker, a lawyer, accountant, somebody that you trust that will be managing the property of the estate on your behalf. Care of minor children, so that goes not only to guardianship. The natural guardians of an individual are their parents, their adopted parents or natural born parents. After the first person passes away, the surviving official parent has guardianship of the minor children. But even if you don't have minor children, but you have under the structure of your will, there's a possibility, unpleasant as it might be, for minor grandchildren, for instance, to come into an inheritance. Hopefully today all of your children will live ad 120, and hopefully that'll be the case in the future as well. But one never knows. You can say, I want all of my 3, 4, 5 children to inherit equally. There's a phrase called per stirpes, which basically means each of those children's heirs would take the place of that individual. But it's possible that today you do a will, and 5, 10, 20 years from now, one of your children will predecease you and leave minor grandchildren. And the question is, do you want those minor grandchildren to have access to your property, to inherit? You want them to inherit. You want them to have the benefit of your estate, what you've accumulated during your life. But you may not want your 15-year-old grandchild to come into a large sum of money because they may not use it as well as you would have preferred they use it, no matter how mature they may be. So often in a will, we recommend that people put provision that if there comes an event where a minor inherits, then until they reach the age of, in Israel, majority 18, 21, 25, I once had somebody choose 35, not so sure what confidence they had in their grandchildren, but usually people, I would say, most people say 21 is the age that they will require somebody else to supervise and manage. The official term is hold it in trust, so they will appoint another relative, a friend, that will manage the inheritance of this minor until they reach whatever age it is that you deem appropriate. One of the messy cases which I spoke about before, which reminds me about the living will. I didn't tell that story. The living will, going back for a second, that's the end of life decisions, must be used in the official Israeli form. I was called a couple of years ago by somebody in the hospital, a client of mine who happened to be there when an elderly Christian woman from Florida who was on some pilgrimage trip to Israel suffered a brain hemorrhage and was, for all intents and purposes, brain dead. And they were hospitalized in one of the hospitals in Jerusalem, and the children in Florida wanted to disconnect their elderly mother from life support systems, and they had a living will from the States, and the hospital involved said, no, we only recognize the Israeli form of living will. And they contacted me, we threatened, doctors confirmed, brain dead, no chance of recovery. In the end, the hospital ended up consenting, disconnected the individual. The children came to Israel to take their mother home, buried them in Florida. The moral of that story, which I'd forgotten to mention, is that if it is important to you to have the living will to determine what your end-of-life medical care is going to be, and you are in Israel a good part of the time, you should do an Israeli living will. Excuse me? The question was, where do you get the form? I believe the Hebrew language form is available at Misrad HaBriyut, at the Health Ministry. If you want the English Hebrew language form, I'll be happy to send it to any of you that want it. Going back to the example, the other unfortunate example that we have here, one of the reasons that you want to have a will to establish how you want personal items to be distributed is if you have something that has particular sentimental value to you and you want a particular relative to have it, the will is the place for that to be designated. Putting a sticky on items that say this candelabra, and I've had, it sounds funny, but people have good intentions and they think that will override a will, or that a court will respect the sticky that says this goes to this relative or that goes to that relative, and it can cause great acrimony between members of the family. To say, on the one hand, there's a will that says X, and you have a sticky which says Y. Well, which was the most recent intention of the person? Well, it might have been more recent than the sticky, but the sticky's not going to be respected, generally speaking, by the court. If you want to designate specifically how you want items of particular value, either financial value or sentimental value, the way to do it is in a properly done will. I mentioned about the taxes. The U.S. federal estate tax exemption is right now approximately $5.5 million. Again, it can be reached easily, or not so easily. Without too much difficulty, it can surprise you. But for that reason, since not all of us have $5.5 million, I personally don't think that that is as crucial to have tax planning in your will as it used to be. The only ones that make money on that usually are the lawyers, and sometimes here when it comes to translating and certifying those translating, lawyers will make a lot of money, or the notary will. I would generally say that unless you have something close to $5 million in worldwide assets, taxes should not be a major concern of yours. What is included in your estate? The United States and Israel have similar provisions today regarding estate taxes, just as they have similar rules today regarding income taxes. If you are a citizen of one country, you are taxed on your worldwide property in that country. Now again, Israel does not currently have an estate tax. It did have years ago. It was canceled. Usually when it comes election time, we'll see what Bibi does with the submarine story or whatever other stories, but usually when it comes time for election time, one of the social parties raises the issue, let's reinstitute the estate tax in Israel, death tax. I don't think that's likely to happen, mostly because the Knesset members who are the ones that vote on these things are the ones that are more likely to have the larger estates that would then be subject to the estate tax. It's possible, but for now, that's not really relevant, and I tell all my clients that if the law changes in the future, I'll notify them, and there'll be a mass need to address tax issues in the future. Different kinds of wills, and before I talk about the different kinds of wills, and I can see from your eyes, you're all asking yourselves, well, many of you are asking, do I need two wills? Do I need a will in the United States? Do I need a will in Israel? And the answer is no, unless you have a will which by its face specifically limits itself to coverage in one country or another, and there can be circumstances where that is appropriate. The example I gave before, you have a long, fancy will for tax planning purposes in the States, and you have a much shorter Israeli will dealing with your property in Israel. So the Israeli will normally say it only applies to property located physically in Israel, and then the old will from the old country will deal with everything else. So it's possible there can be circumstances where it might be advisable to have a will specifically limited to one country or the other. But in most cases, if you're doing a will today, and unless you for some reason do not want to disclose to one country or the other, which I'm not advocating, but if for some reason you want specific assets to be dealt with in a different way and would want a separate will, you can have an Israeli will which will be completely binding, at least in the United States, may not be binding in France. France has weird rules, like in the States. When we were going to law school, we always said the state which had the most unique laws which caused everybody trouble was California. So just like when California with general law, France has this unique way of dealing with death and estates, but in most regular countries, certainly the United States, and okay, no offense intended to anybody from France, certainly if you're from the United States, you do a will in Israel, it will be recognized in the States. You do a will in the States, it will be recognized in Israel. There may be procedures that you need to go through. You may need, if you only have one will for both countries, your heirs will have to process it, called probate, first in one country, and then usually get a certification from the court in that country while you're no longer filing the original will, which you need to file in the other country. And the reason is because you filed it already in country number one, and here you have confirmation from the court in country number one that the original is there, and here you have a certified copy to file in country two. Anyway, there are 4 main categories of wills that can be done. A holographic or oral will is a will that is done ba'al peh. Usually in Israel it is only valid at a time when a person is imminently dying, bleeding. The doctors say they have hours to live. They hadn't previously done a will. They take two witnesses. They say orally to those witnesses what they want done, and then the witnesses must immediately afterwards record it in writing and certify it, etc. If they don't do so, it can be invalidated. If the person recovers and doesn't die, it's as if they never did it in the first place. But obviously it's quite risky for several reasons. One is the time the person is imminently dying is not the time to make logical, informed decisions as to how you want your property to be managed, what you want done for your things. You're probably thinking about other things, and you don't want to have to rely on having the clarity of thought. You clearly are under duress, under stress, and a family member who may not like what was said in the oral will can easily challenge it. The person was under duress. They didn't have any mental capacity to make proper decisions. You don't even know if the individual understood what they were doing because the witnesses themselves may not have known. You have no way of confirming that the actual witnesses were present because you don't have a lawyer or somebody else, an objective third party, supervising the process. The oral will is therefore highly recommended against. A handwritten will is slightly better. A handwritten will must generally be completely in the handwriting of the individual. It must be dated in the handwriting of the individual, and it must be signed in the handwriting of the individual. And virtually by definition, there are no witnesses for a handwritten will. So by logic, since you have no witnesses, there's nobody that can certify what the mental capacity of the person was at the time. You have no way of knowing if somebody was holding a gun, a literal gun or a figurative gun at their head at the time when they were doing the handwritten will. It could be a forgery. It could be, there's so many easy things that a lawyer could challenge with a handwritten will, not to mention the mere fact that it's done in handwriting suggests that they didn't have a lawyer guiding them in the drafting and preparation of the will. So it's the second worst, I'll call it, the second worst way of doing a will other than an oral will is to have a handwritten will. The will that obviously I will strongly recommend that all of you do is what we normally think of when we see a will, which is a typed will, which is witnessed in the presence of two witnesses who sign in the presence of the testator. That's the male version of the person who is doing a will, or the testatrix is the female version of the person that's doing the will. The witnesses are there. They certify that the person understood what they were doing. Usually when we do wills, even husband and wife, we send the spouse out of the room. We don't let children be in the room at the time when the person is doing the will, so that nobody afterwards can say, well, they were pressured. They had, I've had people come with their grandchildren to do their wills, and I don't know what happened before they came into my office. I do know that when they're in the office, I will ask the individual questions to make sure that I feel comfortable that the decisions that are being made are their own decisions and not decisions that their grandchildren made. I've had some elderly clients that until I finally put a stop to it, they would change their wills as often as I changed my socks. This grandchild came to visit me more this month. That grandchild came to visit me. It's funny, but there are people that do that. They maybe don't care about the money that they're spending on doing the wills, and they want to either punish some relative or friend, or they want to reward other relatives or friends. And I tell people that this is a serious matter that you're undertaking when you're doing a will. It's something that should last, God willing. It won't need to be used for many years in the future. It's not something that you should take lightly. It's not something you should be pressured either by people being present or by current relationships or changes in current relationships. But it should be something that you think about, that unless something drastic changes in the future, you shouldn't anticipate making changes. Even if you need to, you don't necessarily have to do a new will. You can do what's called a codicil. A codicil is a fancy word for an amendment to the will. has to be done in the same formality as the will itself, so you'll have a typewritten codicil normally prepared by a lawyer that will be witnessed in the presence of the lawyer. One of the things I did, which I adopted from my years of practicing law in New York State, was I require virtually every will that I do, whether it's an Israeli will completely in Hebrew or an Israeli will in English or otherwise, I require all wills to be done to have an affidavit of certification at the end, which is technically not required either under Israeli law and in most cases under New York law. It creates what's called a self-proving will. If there's no affidavit signed by the witnesses in the presence of a supervising lawyer, you may have to bring the witnesses into court when the person passes away to prove that they were actually present, there was no duress, the person was of sound mind, of the right age, etc. I became particularly sensitive to this when I was a young lawyer. I wonder if my wife, who's sitting on the side, even remembers this story. Hi, wife. But one of my first assignments as a young lawyer was dealing with a will of somebody who had lived in, I forgot the name of the building, by Strawberry Fields, where John Lennon had lived. And, excuse me? Okay. Don't remember the name. It was many, many years ago. Your memories are much better than mine. But this was in the case of somebody that had a will that did not have a self-proving affidavit in it and had two witnesses who had signed the will, and many years later, my assignment was to bring these witnesses into court. And I was able to go to whatever the building's name is by Strawberry Fields and look for these two witnesses. And the two witnesses by then had long died. And we had to go to great lengths to prove the validity of the will in the absence of having this extra affidavit, which I customarily, many other lawyers do as well, but I make it as a mandatory part of the process, which I learned from doing it in New York. In Israel also, the witnesses sign on the will. The individual who's giving the will declares out loud that they have read the will, they understand the will, they're of sound mind, they're not under duress. They all usually laugh when I say they're at least of 18 years of age or older. I haven't done any wills for people who are less than 24, 25. Most of my clients are 50, 60, 70, and they all get a chuckle when they have to read out loud that they're at least 18 years of age. But they sign on the will itself, and then they sign a separate affidavit, basically going into the background again of the process for doing the will. Again, when you're going to a lawyer that prepares a typewritten, these days it's not really typewritten, but computer-generated will that's prepared by the lawyer will give advice that some people may not consider the possibility that a child, God forbid, may predecease between the time of the will being done and the time the person passes away. They may not be aware of the issue regarding joint ownership of property, and they may assume that X will be automatically transferred to the surviving spouse when it doesn't. They may not realize that life insurance and other insurance policies and other things with designated beneficiaries are excluded from the will, so if they assume X, there are all kinds of issues. When I have a client that comes to me to prepare a will, the first thing I do is I give them a questionnaire, which after all these years in Israel, I think I'm up to version 19 or 20 of this questionnaire, which evolved over time as I became increasingly sensitive to issues that I recommend to people to consider in doing the wills. But I generally require them to complete the questionnaire in advance, submit it to me, I review it, and then we discuss issues either on the phone, by email, or in person, whatever they choose. The last general category of wills is one before an authority. In this case, an authority is generally a judge, an Israeli notary, some other public official. It adds, in my opinion, a level of expense and complexity to the process which is not necessary. You can just as easily save a little bit of money, have your lawyer produce witnesses that he or she trusts to witness your will rather than going to an authority, but it is a possibility that you can do if you are so inclined. I've mentioned a few times the issue of testamentary capacity. That is one of the easy targets for a lawyer who wants to attempt to challenge a will, either to say the person was under duress or the person didn't know what they were doing, they were already elderly, they had Alzheimer's, some other disease which impaired their mental capacity. Maybe they were drunk at the time, they just gotten married in some whatever, and they did a will, and you want to make sure you have witnesses that can confirm that it was done properly. I've already described some of the process that we use to attempt to ensure with an E that there is testamentary capacity and no duress forcing of the issue upon the person making the will. In the old days, there used to be the common practice, husband and wife did one will. They signed it together, and the wills usually said, first one passes away, everything goes to the second one passes away, goes to whoever else. That concept fell out of favor many, many years ago. I went to law school, graduated in 1981. I think already by 1981, the concept of doing mutual wills, two people using the same will, had already come out of favor and is greatly discouraged these days. The most important reason is it limits the survivor, and even at the time before the first person passes away, it limits the ability to amend or change or replace the will in the future. You may even have to go to court if one of the parties wants to make a change in a will that was jointly signed by the other party. And in fact, in most cases of husband-wife wills, again, I will have separate wills for husband and wife, and I will expressly have them state in the will that it is not a reciprocal will, and that either of the parties, under whatever circumstances, has the right to make changes or replace their will in the future, whether remarriage or some other circumstance comes into mind, whereas they would not have, at least to that degree of flexibility, in the event that there were, in fact, mutual wills. Duress I spoke about already. I also spoke, you don't need multiple wills. If you have a valid will from the old country and it is not limited on its face to property in that country, it will generally, again with the exception of France and maybe some other countries, it will generally be enforceable in Israel. You may have to jump through some hoops to do it, but it can be done. If you have an Israeli will, it will be recognized in Israel, in the States. You do not have to do separate wills for each. You can if you want to. There are ramifications today that wasn't so much the case maybe 2 or 3 years ago. I still stand by my comment that a will done in the States will be generally enforceable in Israel, but wills in the States are done differently, generally speaking, than wills are done in Israel. When a lawyer does a proper will in Israel, they will name the individual, they will usually give identification numbers, whether it's a mispar zehut or a passport or social security number from the old country, usually an address. Sometimes in the States they'll use an address. They will almost never define a person by a number. So up to a couple of years ago, I would say, fine. My experience over the past year or two is that the courts, when it comes to processing a will from the other country, will look for these numbers. And again, the improvement of technology, a lot of the process of probating an estate, of getting a court to approve a will, is done at least initially by computer, and the computer has a line on it. You have the name of the heir or the name of the person making the will, and it says you have to put in the ID number of that person. But if you don't have an ID number in the will, then you have to prove that this person today is that person that was named in the will. That can be done through many complicated, very complex, annoying ways, but it can be done. But as of today, if you do a will and from the old country you need to probate it in Israel, You don't have a number, you have to make up a number. And then, because you won't be able to file it without a number. So you can do 111, whatever the number is, that would be the numbers for a mispar zehut. But when it comes to the court's going to look at it and say, well, how do I know who that is? Well, you have to bring affidavits from people who knew them for 30 years. You have to bring an immediate relative. You have to bring apostille certifications from a notary and the court, or signed at the Israeli consulate, wherever it is, to prove that these people are one and the same. So I still stand by my position that a will that's done properly in the States will be accepted and ultimately approved in Israel, generally speaking, but it's not as pashut, as simple as it was in the past, and it will have ramifications on costs involved in processing the will afterwards, and the time that it takes to get the court to approve the will. I've had wills, usually the fastest that you can get a court in Israel to approve a will fastest is 3 to 4 months. And I've had wills that have dragged on for 1 or 2 years, even without opposition. When you have somebody that's opposing it, that can take much longer. But even if you have a will and everybody agrees with it, and nobody is objecting, and you have the good old apotropos haklali that throws this monkey wrench or that monkey wrench into it, can easily take several months to a year or more. I mentioned the translating costs, spoke about the numbers in the document. Halachic issues, I'm not going to speak about it at length. Those of you who are at shul, last Shabbos, 2 Shabbatot again in Pashat Pinchas, learned about Slavchad and what the ramifications are of having only daughters, no sons, according to halacha. Again, without giving a halachic opinion, if you have, for instance, a male relative and female relatives, the male relative will generally inherit everything. If you have sons and daughters, the sons will get, the daughters will not get. There may be mezonot that a female spouse gets. There are all kinds of complications. Usually, people don't want their estates to operate the way pure halacha dictates the distribution of the estates. So what do people do? So there are a couple of different concepts which I liken here to the use of a prusbul or selling chametz on Pesach. You have a document either which establishes a pre-death gift which conforms to the terms of the will, or sometimes you have a matnat shchiv meira, machmat mita, various options that will create a debt in favor of one of the heirs who would not inherit under halacha, and basically the other heirs who would inherit under halacha will have the option. They can abide by halacha purely, or they can waive their rights in favor of the person who has the debt, because the debt will usually exceed the total value of the estate. There are many options that are available to people that want to comply with halacha. Over the years, I can say that not many have. I'm not saying that's a good thing or a bad thing. I usually tell people that if you are concerned about halacha, you go to your own Rav, ask your Rav which of the many options they want, and I will take care of it. I won't charge. There's some people that charge extra for halachic wills. I personally find, I think of it in terms of a prusbul and a selling chametz. I don't think it's something that people should profit on by complying with halacha. So if people are sensitive to the issues of halacha, ask their Rav. If the Rav has their own form, we'll use their form. If the Rav chooses an avenue and I have the form, I use the form. Whatever people have, I'm happy to comply with. And that is the halacha. Again, the halacha does not prevent you from having a will which does the distribution the way you want it, but there are ways of addressing the halachic needs which do not cause the violation of halacha. And I thank you, and if you have any questions.